Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, lovely people. It's another Saturday afternoon, and we are live on BWTV bringing you The Community and the Law. My name is Oreku Frimpon, and I am so privileged to be the host for this event. We're going to look at the ingredients for a successful appeal against a UK visa refusal. Remember, we're doing this courtesy BWF Solicitors, and Lawyer Charles Asma from BWF Solicitors will be with us this afternoon to help us look at what we need to gather when we are going to appeal against a UK visa refusal. There have been updates, and of course, there are other things that we need to share with you, including the quiz question that I have and what I bring always at the tail end of the program. So if you're ready, let's get into this together live on BWTV. We're streaming live on Facebook and YouTube at BWF Solicitors and at BWF TV. And of course, you can call us on 0208 493 7345 when the lines are active, so you can bring in your question or contribution, and Lawyer Charles Osman will help us do that. But if you're contacting BWF Solicitors, what I want to say is call them Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. They are on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. The telephone number is 0208 493 7340. 0208 493 7340. Those in Ghana, there's an office in Ghana where you can access the services of BWF Solicitors, and you can reach them on 055 589 5959. 055 589 5959. But in all situations, all emergency situations, 0044 7712 761884. 0044 7712 761884. You can find all those numbers and the social media handles at the bottom of your screen. Yes, and I want to tell you that there are things that we share with you. So those of you who have joined us, please make yourselves available and announced on the platforms. Happy birthday, and happy birthday once again to our very own Pamela. Pamela is now a trainee solicitor and also a caseworker at BWF Solicitors. She starts the month of October so very well with us, with a bright, wonderful smile and the celebration of a birthday. So on behalf of our clients, on behalf of every member of staff, on behalf of the production team here on BWTV, we want to say happy birthday, Pamela. You hear from her on Thursdays and sometimes sits in my seat on a Saturday afternoon, so you know who I'm talking about. So Pamela, thank you very much for being who you are and doing what you do. And we say enjoy your new age. There are a lot of things ahead that will make you successful, so keep doing them. And as I said, you welcomed us to the month of October, the pink month, where we have breast cancer awareness. So happy new month to all of you. And those of you who would want to send any contribution as far as breast cancer awareness is concerned, send them through to our text number 0739920848, 0739920848, or you can drop them or DM us at our social media platforms, Facebook, YouTube, LinkedIn, and any other one that you are conversant with. So we can share with people your experiences, the bits of knowledge that you want to put across, and we will all stay safe and be aware of the difficulties cancer take us through, especially our female persons we live with, moms, sisters, daughters, friends, and the rest of it. Yes, so we're plodding on, and I was welcoming you to the month of October. And I want to reiterate that if you have anything to share with us, please don't hesitate to drop it, and we'll share it on the program. The next thing is to look at the month of September 2025. Last week, those of you who were with us, I mentioned that when we start a new month, we look at the previous month where we kind of assess the work of what people do here at BWF Solicitors, and staff nominate one person to be the employee of the month. For the month of September 2025, ladies and gentlemen, we had our very own Annie Soa as employee of the month. We're so thrilled to recognize her as employee of the month for her outstanding contributions. Her dedication to handling the complex cases was truly exceptional, leading to positive outcomes for our clients. If you remember, at least 2 of the 3 weeks that we had in September, people were congratulating her and expressing something very positive about what she's being able to do for them. So, Annie, we say congratulations. We know you consistently embody the firm's commitment to excellence and client service. So, once again, on behalf of everybody, we want to say congratulations to you. Keep doing what you do. Thank you. And to our client, Mohammed, we're also expressing their satisfaction as to what BWF Solicitors is able to do for them. Thank you, BWF Solicitors, he says, for helping with my case, especially Abigail. I want to thank Ade for helping with my e-visa. Well, that's also another thing we want to really bring across, that with the e-visa thing, the offer BWF solicitors give you when it was introduced is still there. So if you have any challenges with registering yourself on the portal, call BWF solicitors on 0208 493 7340, and we'll get somebody to help you do that. That's one of the very wonderful services we offer to the community. So if you would want to have help with your e-visa or any other thing, call us and we will direct you to the right place so you can get the appropriate help. The Home Office has come up with something new, and I want us to share it. They say that they have provided an update on the proposals to change the requirements for settlement, that is indefinite leave to remain. Listen, it's been announced that a contribution-based settlement model will be introduced. Under the proposal, the qualifying period for settlement that is indefinite leave to remain will increase from 5 years to 10 years of lawful residence in the UK. The model will allow applicants to shorten these 10 years if they meet specific earnings or integration criteria. And what would they have to meet? So to qualify, applicants would need to demonstrate, one, being in employment and having a minimum national insurance contribution. I think we all do, don't we? The second one, not having claimed benefits. Third, meet a high standard of English language proficiency. Then the person would have maintained a clean criminal record, provide evidence of giving back, such as volunteering in the local community. This is quite extensive and broad. So if you want more information on that, visit our social media platforms, Facebook, YouTube, X, LinkedIn, and all the other ones at BWF Solicitors, and find information there. Or you can call us on 0208 493 7340, and we will support you with that. But with that, let me just jump some protocol things and introduce our resource person and guest for the afternoon. He's a lawyer at BWF Solicitors. I always call him our friend and our brother and our teacher, very methodical with his presentation and things he takes us through from the Western region of Ghana. Uncle Charles, good afternoon.
Why do you say Western region?
That's what I want you to be. The best comes from the West.
All right, okay. I would have loved to have heard Central region.
Central region. I know if it's for Central, no, Western.
No, Western. No, I can run, I can off.
Okay, no, me I can for 20 years on the phone. Thank you very much for your time this
Pleasure,
afternoon.
pleasure.
I always say we don't take your contribution and time for granted at all, because it could have been time for you and the family, but we are able to bring you on TV to help people. So we're grateful. And on behalf of everybody, we welcome you once again.
Thank you very much, Ragoku. It's a pleasure to see you every Saturday. Um, to bring to bear your broadcasting skills and the journalistic acumen and presentation prowess.
Oh. you see, that's why I took it to the West, because it's always with big words and all that. But yes, I'm honored. Thank you very much.
Pleasure.
It humbles me as well. So, brothers and sisters, ladies and gentlemen, yes, I took time to introduce our resource person and guest, Lawyer Charles Asma, and I would want to put on display the very first thing, the um, update. Or let me even do it properly, because obviously we need to celebrate what has to be celebrated. Our very own Pamela celebrated her birthday earlier in the week and started off the month of October for us so very well. I know she is somebody who learns from you and all the other senior members of the family. So I will give you the opportunity to wish her happy birthday.
A very happy birthday once again, Pamela. Pamela, you work so hard, you deliver excellently, you make clients happier, and grateful for everything that you do for the firm, for us as members of the team. And yes, I know that this year that you have is opening so many other opportunities. And next year, once again, we'll be celebrating, and not just celebrating a birthday, but counting the blessings one by one. Once again, enjoy the moment.
Thank you very much. There's one particular thing about the client review this week, and I am going to bring it up because oftentimes we know that you, the lawyers, or the trainee lawyers, or even to some extent the case workers, are the ones that are often in the front line. But you would realize from this, from Mohammed, that we're looking at Abigail, who sits with the uh, sit at the front desk, let me put it that way, welcome people in here. And in the back end of the whole service you provide, Ade is also being recognized here. Particularly, we made the offer when we said to people that if you have challenges with setting up your e-visa, come to us. People would expect that you go straight to lawyers, to the senior partner, the partners, and all the other lawyers in there. But he has taken time to support somebody, and the person is appreciative of that. I believe it gives you some good feeling within you.
It is, and it does. It is a good feeling and gives sense of satisfaction. I think from what you've said and what the client is also saying, and everything else point to the fact that here at BWF Solicitor, it's all about teamwork.
Right.
It's all about a synergy. It's all about a collegiate approach to delivering service to the community. So you don't just see lawyers; you also see um, our case workers, you see the IT support, you see a range of people, professionals who bring everything together to make it work for you. So when you see that your visa decision has come through and will call you to say that, please, a home office has granted, come and pick it up. Don't think that it's just only the lawyer, but it's a whole range of other people. The first time when you came, you spoke to the reception desk, the managers there. They welcomed you. You spoke to the lawyers. Somebody made photocopies of your documents. Somebody scanned them and follow ups here and there. The e visa that has been mentioned. So our case workers and all the support staff, together with the lawyers, make the team BWF solicitors. So I'm happy to say that we are reflecting that that quality, the quality of teamwork and the collegiate approach. And you can see from the experience of this client that this time what happens at the back end has been experienced at the forefront through Adai, one of very experienced, hardworking member of the team, and of course Abigail, very hardworking, and on point, delivering for clients. So that is exactly the point.
All right. Thank you very much. So, Mohammed, and people who have experienced services like that, please let us know. Feedback is always very important. So we can correct what needs corrected, and we can be encouraging people to also continue to do what needs to be done. Well, lawyer, there's this Home Affairs announcement, the contribution-based settlement model that's being announced, and I believe it's something that would excite people, would need some explanation as to how it will work and the rest of it. The Home Office is saying that um, indefinite leave period is going to go to 10 years, but people can shorten that when they satisfy certain conditions. What are these and what's happening?
Thank you very much. So it's more like less like everybody is saying something who is first to do it.
Okay.
And that is what we are saying. We heard from the conservative leader, we heard from
Reform.
the reform leader, and we heard from the labor, and now labor is in power, and they are saying that, you know what, everybody is saying it, but we want to tell them that we have the power and we can start it first. Yes, it's a policy. But once the Home Office announces that they intend to implement the policy, then there's going to be a policy framework, which is case working guidance. So we are likely to have the policy anytime soon. And in the policy, we hear about point-based system, PBS. This, I call it CBM, contribution-based model. Sounds like a management theory. Contribution-based model. So the contribution-based model, what they are saying is that to have indefinite leave to remain granted, you have to wait for 10 years. Well, already people are waiting for 10 years anyway, okay. But largely some are also waiting for 5 years. But what they are saying is that if you want it short, for 5 years or even shorter than that, they didn't say how shorter it will be. They said if you want to shorten it, they didn't say to shorten it to 4 or to 2 or to 3 or to 5. They said if you want to shorten it. And therefore, you can see that at the moment it's vague, but it's going to happen. So let's embrace ourselves. But all that is saying that we're going to know what sort of contribution in terms of national insurance. They say the minimum. What is the minimum? Well, national insurance contribution is subject to how much you earn. And there are people who don't pay national insurance contribution at all because they are not earning enough to attract contribution. That's right. And so if I don't earn enough and I'm not contributing even the minimum, and that's going to affect my indefinite time, what they are telling me is that I have to find a way to work harder, work more, make more money so that I can contribute more. Contribution to that. So there's no option for people who want to shorten it to say that I'm doing a part-time job. Okay. They have to find a way to do extra work so that you can contribute more. Again, they are saying that suitability is going to be very, very high on the table in terms of character, conduct, behavior in the country. And that is also to warn all of us. We know already that suitability is an issue, but if they are going to bring this up, then they may fine tune it and make every bit of issue, every issue a point for them to rely on to say that because of this, you cannot. And so we are likely potentially to see that the things that call for suitability may be enhanced, so that if it is drink driving or some other related issues, which in the past may not necessarily be an issue, they may make it an issue. We don't know how they're going to do that, but we wait to see. But this just to let us know that yes, Labour, the government in power, intends to implement the policy that Conservative and Reform have proposed, and it's not good. More or less, we're now going to have a collective way of getting this sorted. So let's prepare ourselves. We don't know when, but once the policy is published, we will take the public through so that we understand the fine details.
So if you want all those details, and that's what we do at BWF Solicitors and also on this program, when the updates come in, we keep you posted and we take you through what you need to do, what you need to understand, and how you go about it. how you go about it is one of the things we're going to look at this afternoon, because the topic we're going to have is all about the ingredients we need to have. We'll need to go into that. So the we're going to have the nugget, really, that would help me ask you my question. It comes as a question, really, that did you know that your 7-year-old child qualifies for indefinite leave? Children born in the UK can apply for indefinite leave to remain based on their private life after 7 continuous years of residence in the UK. So, to qualify, the child must have lived in the UK continuously since birth for at least 7 years, and it must be considered unreasonable for them to leave the UK. So, to qualify for a grant of leave under this policy, um, the person would need to show that when the child is under 18, the child was born in the UK, the child had lived continuously in the UK for at least 7 years, and it would not be reasonable to expect the child to leave the UK. This is more of what is in Appendix Private Life PL 3.1 of the immigration rules. Like Asma, isn't that a new thing?
Well, it's a reminder,
Okay,
an assurance
right.
that it's there and it's working. You can take advantage. Because some people don't know that when the child is 7 years, the child is a qualifying child.
Okay.
When the child is 7 years, whether they have papers or no papers, the parent can apply through that child. But what's the point the parent applying through the child without thinking about the child?
The child, yeah.
And so to think about the child, the law says that the child is 7 years and born in the UK, that's the key thing, born in the UK.
Right.
Because if it's just a case of 7 years in the UK, then foreign children can live in the UK for 7 years, but they don't qualify for indefinite leave to remain. And so once the child has been born in the UK and the child is lived in the UK continuously for 7 years, and the key word is continuously, for 7 years, the child can apply for indefinite leave to remain. Somebody will ask, oh, but lawyer, we hear that that child can apply for citizenship. That the child must be 10 years. So 10 years citizenship, 7 years indefinite leave to remain. So let's keep the two in mind and note the difference. So it's assurance and also refreshing to note that the rules allow for children born in the UK and lived in the UK for 7 years to apply for indefinite leave to remain in the UK. And through that, parents can also apply to remain with that child.
So the conditions is talking about the child being under 18. Why that?
Because a child is defined within the statute, that's the Children Act of 1989 and other statutes, that if the child is 18 years, that child is no longer a child.
Okay.
You may be a child because your parents are still feeding you, but you are not a child in the eye of the law or the public. Okay. And that is why at 18 years, there's something you can do with adults. What is that?
I'm lost. Oh, you can vote.
You can vote.
Okay. The universal adult suffrage.
So you can vote at 18 years.
So you know what came to mind? I was thinking, is there any application that could be made when a person is 18? So I was lost.
Yeah. So a child is someone under 18 years of age. So the person must be under 18. And of course, the person might have been born in the UK. And of course, the person might have lived in the UK continuously for 7 years. What do you mean by continuously? If, for example, in the last 1 year, the child has been taken abroad and brought back, I don't know how the child will be brought back anyway without visa. But whichever means, the child has been brought back. How long has the child been away for? 1 year. Has the child been continuously resident in the UK for 7 years?
No, because there's a year lost.
Exactly, and therefore the child will not qualify. So born in the UK, lived in the UK continuously for 7 years, and of course under 18 years. And what's the fourth one?
The fourth one says it would not be reasonable.
for the child
to leave the UK.
So when we say reasonableness, you are looking at a child that has lived 7 years of life in the UK.
Mm-hmm.
At 7, you become aware. So there's general awareness of your environment.
Okay.
So if I've lived in the UK for 7 years as a child, what will I have?
You would have formed relationship, friends, peers of school, church.
Good. And there's also you would have also had what we call life in the UK experience.
Okay.
Life in the UK. So life in the UK is not about the test, but it's about the fact that the child has had life experience in the UK.
Okay.
And presumably will believe that this is my home.
Yeah.
And so when they are going away, they will think that they are going on holiday with a view to come back home. So if you are asking this child to leave the UK, is it reasonable? Does it make common sense? That this child should go back or should go somewhere and start all over again, form associations and all this, the language and all these things. And therefore, to not be reasonable for the child to be removed from the UK and to start life elsewhere. So simply what we are saying that if the child meets criteria 1, 2, 3, and the fourth one, which is a discretionary consideration, then we can conclude that if this is all that has happened, then it will not be fair on the child to be refused a visa with a view to be removed from the UK.
So by extension, are we saying that the parent of this child who's lived in the country for 7 continuous years, less than 18 years old, and we would not want this child to leave, so the parent could also say that, well, I am the carer of this young person. If the child is staying and I am leaving, then you are depriving that child of a parental relationship. So then the parent can, by extension, depend on this child's ability to stay here and their right to stay, to also apply for some form of validity.
Exactly. And that is why we say that if you have a child 7 years in the UK, whether they have visa or not, that child is a qualifying child because they have a home in the UK. And it will not be in the best interest of that child, to follow the parents to leave the UK. Because if the parents were to leave the UK, the child must be behind. Because we are saying that a child who has met all the criteria can even apply for indefinite. And indefinite means this is your home. So if the child is okay, and you tell the parent to leave, who's going to look after the child? Common sense, isn't it?
Yeah.
And so under Section 1 of the Children Act of 1989, we are saying that the best interest principles of the child will be affected if the parent were to be removed. Because even though it is not a child that we are asking to, we are requesting removal, the parents who are here for a reason. The child. And so if the child can be here, then it stands to reason that the parent must be here to be able to, then the parent must be here for something, not for themselves. So if you are proving that you are here because of your child and you can't leave because of your child, you have to show that you are playing a role in the child's life. And that is why you have to provide the evidence of what you do for the child, which makes your presence in the life of the child useful. So if your presence is useless, then you will be asked to leave and the child may be behind. But why will a child be behind if they only rely on that parent? So these are the reasons why we are first advising that if your child is 7 years, apply for indefinite for the child. Again, if your child is 7 years and you are a parent, you can apply for 2.5 on the basis that you play a role in the life of this child, and therefore your presence in the UK will help the child's upbringing, growth, and total well-being. And that if you are to be denied a visa, it will not be fair on the child.
It will not be fair on the child, and obviously you would want to protect the interest of the child. So think of your children, those who were born here, lived here continuously for 7 years. Make an application for them if they do not have any status, and then they will be protected. And you could also benefit if you also fall in the situation, the category where you don't have anything. Thinking of that, we refer from the Appendix Private Life PL 3.1 of the immigration rules. So then, based on that, let me ask you this question. Kofi Tubam, who was born in New York in 2017, is our focus here. When he was 2 months old, his parents came to the UK as visitors. In 2025, look at the timeline very carefully. He was born in New York in 2017. He was brought in the same year, 2017, when he was 2 months old. They came in as visitors. Okay. Now, in 2025, when Kofi turned 8, his parents applied for indefinite leave to remain on his behalf, relying on the new law under the private life category. They were told by the Nokofio Advice Center that once Kofi has settled, they can apply for their own settlement. So then I go on to ask you this question. Does Kofi qualify for indefinite leave to remain as he's been in the UK for more than 7 years? I have 3 scenarios. Choose one. Yes, because he's lived in the UK for 7 years or more and is under 18 years old. No, because he was not born in the UK, although he's been here for 7 years. And the third one is no, because his parents do not have indefinite leave to remain yet. Kofi, remember, was born in New York. He was brought in. Mom, dad came in as visitors. They stayed on till now. In this year, 2025, Kofi turned 8. His parents have applied for indefinite leave to remain on his behalf, relying on the new law under the private life category. This Nokofio Advice Center, these people who profess to be providing immigration advice, said that yes, Kofi settled, so they can apply for their own settlement. When Kofi settled, so to speak, they can apply for their own settlement. But the question is, Kofi, does he qualify? We have 3 answers. Yes, because he's lived in the UK 7 years and more and is under 18. We're saying Kofi cannot because he was not born in the UK, although he's been here for 7 years. And 3, we're saying no because his parents do not have indefinite leave to remain yet. Think of it. I'll come back and ask you again. But before then, let's say thank you to our benefactors, BWF Solicitors, our trusted partners when it comes to the law. They help us with all immigration matters, family issues, when it comes to property and investment, and also business development, anything in the law. They are there to help us. 4th floor of Viana House, 214 to 218 Tottenham High Road, 7 Sisters in North London. Call them 0208 493 7340 0208 493 7340. And this message is going for them.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, we're right back, and thank you very much for sticking around. BWF Solicitors, proud to be associated with the community and the law. I would want to remind you that they are located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. Those of you who have joined us, we are live at BWF Solicitors Facebook, at BWTV UK Facebook, BWF Solicitors YouTube, BWTV UK YouTube, and you can also watch us live on all our social media platforms. Those of you who are there, let me remind you that I have seen you and I want to recognize you. Tiliduma, you're there. Thank you very much. Kindly share, comment, and like as you say thank you with a thumbs up and lovely face smiley. We have Nanaya. Blessed Saturday to you. You're watching us live on Facebook. Thank you very much, Nanaya. Citizen Kwejo, you have already answered my quiz question. That's brilliant. You say it's number one or A. We'll come back to that, don't worry. Then we go to the next person. I know Sandra Fraser is done her thing. Yes, she's provided every detail you need to have about BWF solicitors. She's asking us to contact the specialist solicitors, giving the numbers, and the rest of you can find that on Facebook and YouTube, and also in the comment section down below. So leave yours there. Share. Nana Jumai, the class prefect, has come up and done that for us. Thank you very much, young team. Good afternoon to everyone. Good afternoon to you as well, young team. God bless you for sticking with us and enjoying the show. What I would ask all of you to do is to share the page, like it, and then promote it to tell people that we are live. And we'll do that every Saturday afternoon between 4 and 6 p.m. UK time. Yes, back to what we are doing this afternoon. We are going to do something very interesting. You may have been refused a visa. And if you remember, there are some remedies that are available to you. One of them is going on appeal. Now, if you want to prepare yourself to appeal against a refusal decision, a visa refusal decision by the Home Office, what do you need? How do you go about it? Is it so desperate a situation that you think that you have to fold your arms or put your hands in your bosom and say that's the end of the story? My dear friends and lawyers at BWF solicitors will tell you no, there could be something that could be done. How do you do that? What do you need? That's why Lawyer Asma is saying we're going to look at the ingredients for a successful appeal against a UK visa refusal. So let me go over to his desk again and ask him visa refusal. One of the remedies, one of which is the appeal. What are they? And what do we need to put together to do that? Sit back, enjoy, pick up your notepads, type up everything that you need to know because it's going to be a very useful learning experience. That I can assure you. Last man.
Sure. Thank you very much, viewers and listeners. So today we are looking at ingredients for a successful appeal soup that will make your Saturday memorable. Not just one Saturday, but every Saturday and a weekday that you have to be in court to challenge a refusal of a visa by the Home Office. So why are we saying ingredients? Because we believe that everything worth doing requires some sort of factors or things to make it work. And we call these ingredients because if you have them, then you are likely to be happy with an outcome that you are seeking. So on this occasion, we are looking at appeals. We know that we apply for visas to enter the UK, to visit, to educate ourselves or gain knowledge, to be with family, or to work. These are four reasons why anybody will apply for a visa, a UK visa. And Brad, I believe you side with me.
Yes.
That there are only four reasons. Apart from you visiting the UK, apart from you joining your family permanently in the UK, apart from you going to work in the UK, and the fact that you want to do A or B, there's no other reason.
There could be educational reasons.
So yes, that's that.
So
Of course,
the fourth one.
the fourth one to learn. So if after this you have refused a visa, then I wouldn't know what sort of visa you may refuse. Yeah. So we know that then such visa refusal is likely to be for visitors visa application. If you are refused a visitor's visa application, there is no appeal remedy for you, because visitor's visa is just like somebody who is throwing a party and saying that you can come, but make sure I say come. That means you can be ready, and they will say, no, please, the place is full. Don't come. There's nothing you can do. It's pure discretion. If they want it, they will let you in. If they don't want it, you stay where you are. You are a visitor. Right. Visitors have less rights. So when you are refused a visitor's visa from 2015, they stopped appeals for visitors visa refusals. So there's no appeal for visitor visa refusal. What you can do is to go to court to challenge the decision on the basis that it breaches Section 6 of the Human Rights Act 1998. If the refusal of your visitor's visa is on the basis that you are visiting a family. So there's no appeal for visitors, but you can seek judicial review for visitors visa refusal. So the conversation is not for judicial review, it's for appeal. So you can see that we are not going to cover appeals for visitors visa refusal, because there's no appeal for it. The other visa that you may be refused is for student visa. Student visa, you are entering the UK to study. Again, there's no right of appeal, but there's right for administrative review. And if there is administrative review, then automatically you are going to move into the next level, which is judicial review. There's no right of appeal for student visa applications. So please bear in mind. That means the conversation for today will not be for student visa refusal, because there's no appeal right there. Then we come to work, skilled workers, or workers in general. You're entering the UK to work for an employer. Again, there's no right of appeal for refusal, but there's administrative review right. And of course, you can extend it for judicial review. So, visitors visa, no appeal. Student visa refusal, no appeal. Skilled worker or workers visa, no appeal. So what has appeal? Any application that borders on family reunion, or private life, in other words, human rights. So if it borders on human rights, you have appeal right. It also borders on EU rights, then you have appeal right. So these are the two areas of refusals that warrant appeal remedy. Now, so for human rights, it could be joining your parent, joining your wife, joining your child. If it's you, joining your parent, joining your wife, joining your child. So these are all options there. Now that we understand that these are the ones that allow for appeal remedy, we are zooming in on appeal. And the question we are asking is, now that I know that my visa application has rights for appeal, how do I go about it so that I can succeed in such appeal challenge? We are looking at the ingredients that will make this pot of soup palatable, sumptuous, and ready to be enjoyed. Now we move on.
Okay.
So there are three things we are going to be looking at, and I've put it together with acronym PET. So we are ET. So we are looking at PET of an appeal.
Okay.
So with the PET of an appeal, which is the main ingredient, we are looking at the preparation as primary ingredient.
Okay.
Preparation for the appeal.
Mm-hmm.
We're also looking at the evidence for the appeal.
Okay.
We're also looking at the timing for the appeal.
Okay.
If you get any of these ingredients mixed up or you apply them wrongly, you are likely to have insipid appeal soup. In other words, you will not enjoy it enough. And we want you to enjoy. Right. So stay glued to your seat and enjoy the soup.
So we're looking at the preparation we need to make. We need to have the evidence that we need to put together and the timing of it. You can't just say, I want to choose my own time to do it. There may be some principles around it. So, my dear friend, I would want you to stay glued to your seat, as he said, but pay particular attention. If you don't learn anything at all, to have a successful appeal, you must have a PET satisfied. The preparation, the evidence, and the timing. Learn.
Right. So all these are taken from a rule book. Because when it comes to appeal, you are not dealing with the Home Office any longer. You are dealing with the court. Mm-hmm. And all the honor, respect, accolades must be given to the court. There are things you can do to the Home Office, but you cannot do to the court and go scot-free. Mm-hmm. You can't put pressure on the court, and you cannot ignore the court.
Okay.
So we are looking at what sort of PET preparation, evidence, and timing do I have to have in place?
Okay.
We are going to start from the back or the bottom, so T. Mm. So we'll look at the timing. We have a book or a law called Procedure Rules for Bringing an Appeal at the First Tier Tribunal. Okay. So there are levels of court. Mm-hmm. You always go to the lower court with your appeal if you have right.
Okay.
If that doesn't work, you go to the middle court, which is upper tribunal. If that doesn't work, you go to appeal court. If that doesn't work, you can even go to Supreme Court, which is the last stop. Mm. But at this point, we are looking at first things first. So the First Tier Tribunal Procedure Rules. The First Tier Tribunal Procedure Rules 2014. So producer will assist us with that. And we are going to look at the timing.
Okay.
So when a visa is refused, they will tell you whether you have right of appeal, administrative review, or nothing.
Okay.
We assume that this one you'll be told you have right of appeal because it fits into the category of refusals that you have right of appeal.
Okay.
So you've been refused and you have been told that you have right of appeal. Mm-hmm. The question is, where were you refused? Very important. But we are looking at timing to bring your appeal or the challenge.
Okay.
If you are late, then you must do something. Okay. If you don't do anything, you are pretending that you are not late, but you are late. Okay. So you've got to do something. So the first thing is, where was the appeal that the visa refused? Was it refused in country in the UK because you applied whilst living in the UK?
Okay.
Or it was refused out of country, abroad, because you applied from abroad to enter the UK?
Okay.
If refused in country in the UK, you have 14 days. All you need is 2 weeks to send your request to the court. You don't need more than that because you're already in the UK and the court is also in the UK and Home Office is also in the UK. Okay. So you have only 14 days from the date of the decision.
But the date of the decision, there's a date that the letter would be written. There's a date that you receive it. And the date of the decision, as you have said. Obviously, you said the date of the decision. So would it be in the refusal letter that it was refused on this date? And
good. So well done for reading my mind and preempting what I was going to say. Mm-hmm. So the date of the decision and what I was going to add was that, but there is a catch.
Okay.
And the catch is what you brought out, and we are going to expand on that.
Okay.
Let's look at it this way.
Right.
You tell me that I have to bring my appeal from the date of the decision, mm-hmm. but you issue the appeal and the refusal and you kept it for 14 days.
Yeah.
And you sent it to me on the 15th day. So
it
when I
means that
received
I don't typically I don't have the
I
time.
don't have. So will I go back to when you actually wrote it on the form? I mean, on the refusal letter, which shows the date of decision, or I should look at when I actually received it. Which one will common sense support?
Well, to me, as a person who is making the appeal, I would say when I got it, because I didn't know you have made a decision until I got it.
Good. So there's something under the rules called the overriding objective. Overriding objective. Producer.
Let's go back to the document. That's
so scroll down. If you look at the overriding objectives, which rule is that? The overriding rule 2, isn't it?
Rule 2. Yes.
Overriding objective. Overriding objective is saying that we want to make sure that both parties are happy.
Okay.
There's fairness and there's justice in the way we are going to pursue the appeal. So that no one will feel peeved or aggrieved at the end of the process. That's the overriding objective.
Okay.
Timeliness, fairness, justice, cost saving, time saving, promptness, and consensus.
Okay.
So if you give me a deadline which is already
passed, yes,
will it be fair?
No.
No. And that would not be in the spirit of the overriding objective. So even though it says that date of decision, it's actually date you received the decision.
Okay.
Because
so why don't they say that specifically and explicitly in the rule to say that date you receive it? Or there is also the fear that myself receiving it will tell you that I didn't receive it on time.
They have to provide evidence whether you received it or not.
Time.
It's not, but so the key thing is this. The person refusing your visa must finish and tell you immediately, isn't it? If you finish the decision, they make the
interest of fairness. Yes.
If you make the decision today, you tell me today. And therefore, within the rules, the court preempts that once the decision is made, the applicant will be notified, and it's likely to be the same day by email most of the time.
Okay.
And therefore, if the decision is today, for example, 4th of October 2025, then you receive it today. But 4th of October 2025 is a weekend. So the caseworker finished yesterday and said, oh, Monday I will send the email. So you've already lost the weekend, which should be part of the 14 days. Will you be punished for it? No. So it's always the date you receive the decision. And your job is to make sure that you provide the day evidence of receipt, which is the email. So the email will say that please find attach the decision of your application, and full stop. That is your evidence, the date, the time, and from where to who, it's all there. And then you can add it. And we'll look at why that is useful. So we know that under timing, we're looking at if you refuse in the UK, 14 days from date of receipt of decision.
Okay.
Even if the rule says date of
when the
decision
was made.
But it must, in fairness, be date when the decision was received by the applicant.
Okay.
What if the decision was the application was made from outside the UK? Should it still be 14 days? Considering that outside the UK we don't have home office. Outside the UK the court is not there. So it would not be fair for the person to be given 14 days as though the person is in the UK. Somebody will argue, but the person outside is also getting it by email. So why can't they do everything? What if I need to go to the court for whatever reason to make my application?
Okay.
And so if you are outside the UK, you have another 14 days.
Okay, so that makes it 28
days
for outside of the UK.
From the date of receipt of the decision. So that under timing, we have two areas. 14 days, 28 days, depending.
14 days in country, 28 days out of the country.
Very good. So all entry clearance that allow for appeal, you have 28 days. All leave to remain applications would appeal 14 days. So let's note the difference.
Okay.
We've also noted that sometimes you put in your application, but you may be late.
Okay.
You may be late because it is not your fault. You may be late because it is your fault. When would the lateness not be your fault?
Having not received it on time,
Very good. Will not be your
your
fault.
fault.
And therefore, if the lateness is the fault of the decision maker, you cannot be punished for it. But the court doesn't know that it is the decision
So you
maker's
have to
fault.
provide
So you
the
have to
evidence.
tell the court, because we are dealing with the referee, not the party we are up against.
Okay.
And so there's what we call timeliness under when you put in your application if it is late.
Okay.
The timeliness is 14 or 28 days. What if you are bringing it on the 15th day, or you are bringing it on the 29th day? Then you have to tell the court that I'm late, but this is my reason. We call it application for extension of time to bring the appeal after the deadline.
Okay.
What if you don't? Then you are pretending that you are a saint, and you are not a saint. So you can only ask for what? Clemency, isn't it?
Yeah.
All right. So that is that bit for viewers and listeners. So extension for application for extension of time. And when you are applying for extension of time, you have to make sure that you provide the evidence. So if it is the Home Office fault, print the email and add it to your appeal application. And when you submit, they will tell you when did you the form will ask you when did you receive that, when was the decision made.
Okay.
They will tell you when did you receive the decision, when was it made. See, and when was it made, you cannot make it up. It's on the form, the decision, the letter. So you quote and put it there. Then when you are submitting your appeal, because the information you have provided indicates that you are in the UK already, the system will pick it up and say you are late. And so once you are late, they will ask you, why are you late? That is where you give your reason for coming late. So you say, yes, I am late, but it's not my fault because I received the decision yesterday after 14 days had already passed from the date of the decision. I attached the evidence of receipt of my decision, which came in the form of email for consideration. Then you give it to the court. Then the court will make a decision on that timeliness point on the basis of the overriding objective, fairness, and also under Rule 4, case management powers of the court. So even though you are late, the court has power, if it is fair, to give you opportunity to continue with the appeal. So that is that point as well.
Okay.
So under timeliness, we have looked at when to bring the appeal, and if you are late, what you must do. So very important.
Okay.
Now we move on to preparation. To bring
we've done T. We're coming back to the very first one.
The first one, preparation.
Okay.
All right. Preparing means that you have made a decision to appeal.
Okay.
What makes you think that this challenge is worth it? Because there's no point wasting time and money to fight a losing battle. You want to make sure that it makes sense to fight. What is the appeal challenge?
Right.
So how do you know that you are right and that when you go to court, the court will side with you? So you have to look at the decision letter.
Okay.
The decision letter will tell you the reasons for refusal. And if the reasons for refusal are such that you are able to punch holes into that, then as part of your preparation, you think about what do I need to counter the point they have raised. And in doing that, you have to know the type of application that you made, whether it's a student visa application. Of course, we said a student visa, there isn't really appeal, but whether it's to join a family, to do this or to do that. Now, depending on the specific application you have made and the points or the reasons given by the Home Office, you know that I disagree with this, I disagree with that. So another ingredient to look at for as part of the preparation is understanding the refusal decision.
Okay.
If you don't understand the refusal decision, then you are less likely to prepare adequate challenge the decision. Okay. So you have to understand. Understanding means that you have to read. Normally, they will say reasons, go to the next page for the reasons. And that is where I usually go. So I read why they are saying they are not giving me the visa. Is it because of the application form information? Or because of documents I provided? Or because I didn't meet the requirements? It's usually the case that you may not have met the requirement, because if it is about misinformation, they would have banned you anyway. So it's likely that you didn't meet the requirement. But is it because of relationship? Is it because of finance? Is it because of accommodation? Is it because of English language? So you have to check and you prepare yourself to counter that point. So the refusal decision is very crucial.
Mm.
The next thing that we will mention, of course, we'll go back to the timeliness, is payment of the appeal application fee.
Okay.
Because the appeal is not applying, making that application is not free.
Mhm.
It's £140 to the
To
court.
put in the application to
put
the
in
court.
yes, application to the court. So you may send your application to the court for appeal, but if you don't pay the fee, it will be rejected.
Okay.
And if you don't pay the fee on time, you can't come back and say, I've paid the money, so let it go.
So does it have to be paid within that 14 days, or you pay when you have submitted your appeal?
So it's 14 days from the date the appeal was submitted.
Okay.
So if the appeal was submitted today, then you have 14 days from today to make the payment. If you don't make the payment, then the court under Rule 4, its powers can reject the appeal. We call it striking out of the appeal application. And once the court strikes out, what the court is saying is that the appeal is no longer going to be entertained.
Let me ask this. Can somebody say that I have acted within the 14 days, the deadline, but I don't have enough to pay for the 140? So then I can take advantage of the court's window of an extra 14 days from when I have filed to prepare myself and get the money to pay. So then I will owe the court for 14 days, maybe.
Good. So that's a good point. And that also fits into preparation then. In preparing, again, whether you can afford or not. Because you are going for a litigation. A litigation is always expensive. So if you put in and you can't afford the 140, then there's no point. But you have 14 days to put in to make the payment. Somebody will ask, does it mean that 14, when we mentioned 14 days before, does it mean that this 14 days is for those in the UK? No. This 14 days is standard for all appeals. It doesn't really matter where you are appealing from. So let's bear that in mind. 14 days standard. Who pays the money? You pay the money through your lawyer. If your lawyer is appealing, putting in the appeal for you. If you are doing it yourself, you can do it. So I usually, as soon as I submit the application, request the link to pay, and I will call my client that, Massa or Madam, get me your card details. I'll put them in. The court will take the 140 so that you don't forget and do not be in the situation that the appeal will be rejected. So that is something that those who are listening and following can also bear in mind, that if you don't, it will be rejected.
So we can also say safely that with the two bits of our pet, the preparation and timeliness, the payment of the fee fits into both. So you have to prepare and get ready with your 140 and also pay at most 14 days after you have filed the application. Yes. Would that be correct?
Yes, from
the time
from the date you
filed the
appeal.
Okay.
Yes. Okay, so now we move on to the evidence. Evidence is critical. So the evidence, there are different types of evidence. We can have oral evidence, documentary evidence, electronic evidence, audio, video, whatever. But most of the time, when it comes to immigration appeal cases, most of the time, people rely on oral evidence oral evidence and documentary evidence. So when we say documentary evidence, what we mean? We are referring to the papers that support your claim. You are claiming that what the Home Office is saying is not true. They have refused your visa because they're saying that you don't meet the financial requirements. Why are they saying? Is it because the pay slip, because of the bank statement, or because of what? So if what they are saying is pointing to any of those directions, and you bring a document to support your claim that you are right. Example here, I have an appeal I'm working on. We submitted the application and it was refused. The Home Office is saying that they checked and the employer number 2 from the sponsor, they couldn't trace it. And because they couldn't trace the employer, they couldn't verify the money from the employer. And so the financial threshold is not met.
Okay.
See how it links. So I told them that as part of the preparation, go and gather the evidence from the employer to confirm that it's a job that is ongoing. And here I wanted a copy of the contract of employment and also the most recent pay slips and also a letter from the employer confirming same. And I told them, go to HMRC to ask for your tax record. But if you are working and you are paying tax, then why are they saying that they don't trust this employer or it doesn't exist?
Could I request for P60, for instance?
P60, but the P60, yes, P60 is also valid. So P60, of course, if it's coming from the employer, but if it comes from the HMRC, it offer much credence in terms of reliability because coming from the government. HMRC is the government. So if the government is saying that the job exists, then who are you, a worker of the government,
to say that it doesn't exist?
And so that's what I've asked them to do. They've provided the evidence. And because we are at the early stages, we are building our case in going forward. So that is what we mean. So once we have the refusal decision and we know what they are saying, we look for evidence counter what they are saying. And that evidence will go into the evidence portfolio or evidence folder. Now, when we say oral evidence, that is when you go to court and speak to the issue. In speaking to the issue, you might have already put together your statement or your words. That statement, we call it witness statement, coming from you, the applicant that has been refused a visa and appealing, or coming from your spouse, if it's a spousal application, or your parent or friends who are supporting the point. So you have the main witness and other witnesses. The main witness is you. Other witnesses are other family members or friends who are providing support or evidence to the case. So your statement will be tested in court, and that is where you get a chance to speak to the judge and for the judge to understand whether you are truthful or you are not so truthful. If you are truthful and the judge say that, I see someone who is giving truthful account of everything, and the judge is saying that you cannot tell a lie. If you can't tell a lie, then it's likely that the document you provided, if they are doubting you, they cannot continue to doubt you. For example, they say that you are not the father or you are not the mother. And when you went to court, everything points to the fact that you are the mother or the father. Then you are. And the court will side with you. So your aim is to make sure that at least as part of the evidence is reliable, the evidence is relevant, and the evidence is pointing to the claim you are making. What do you mean by the evidence must be relevant? You've been refused a visa because they are saying that you don't meet the financial threshold.
Okay.
That's what they are saying. You don't meet the 29,000, so we have refused you. You have to go and bring photos. So photo may not be relevant. They are not talking about photo.
So evidence of what you earn.
Evidence of what you earn. Everything pointing to the issue at stake. Because the point at issue is whether you meet the 29,000 or not. So everything about your earnings and not relationship. And not living together.
So you don't bring matters that are not relevant to what is at stake in court. You don't go and waste the court's time by saying that I'm in a relationship with this when the refusal was based on the fact that you didn't have money.
Good. So that's what we call narrowing the issue.
Okay.
So you always narrow the issue to be addressed by the court. And the issue to be addressed is based on the reason for the refusal. So you always read the refusal decision, identify the reason, and itemize them. How many reasons have they given for the refusal? If it's one, you are addressing only one with evidence. If it is two, you are addressing two, and so on and so forth. So if it is one, and you are bringing something to say, I want to show them that yes, I am Oga. Then look, you are only wasting time, because that evidence may not be relevant. Because they have it anyway.
And so, what could that even affect your credibility? Because we haven't asked you the question, and you're bringing in one things.
Well, it doesn't affect, but it only wastes your time and resource.
Okay.
So you have so normally, if it's an application that you provided the photos and the marriage certificate and birth certificate and every DNAs and everything, you have them already. So that's fine. It's there. But your focus is where the issue is. So you don't focus on things that you don't have to bother about at the expense of the ones you have to bother. Because when you are focusing on the ones that are not relevant, you end up missing the point for the ones that are relevant.
Okay.
And so the court is asking you, is this evidence relevant? How do I know that it's relevant? The evidence is supporting your case, not undermining your case. And the next thing here would be, is this relevant? So you have, for example, been refused on the point of relationship. Because they are saying that we don't trust the birth certificate. And therefore, we don't trust that you are a family member. And so you have been refused. And you want to prove a point. So you go and get a DNA done. And unfortunately, the DNA didn't go your way. Will you send it to the court and say, look, this is it? I've done a DNA.
You're shooting your own self.
Exactly. And that would be undermining to your case. Because if the DNA doesn't support, then it means they are right.
They're right
to say that there's no relationship. And so before you set out, the evidence must support your claim. If the evidence doesn't support your claim, don't attempt in the first place. So we are narrowing the evidence and targeting it to the issue that we want the court to help us to resolve. Right. Now, once we have put together all the evidence based on the reasons cited, the next question is, how do we present the evidence, and when do we present the evidence?
So we still have to keep our timeliness in mind.
Yes. So under the evidence threshold, the court expects you to file your case, and this is how it works. Home Office has 28 days from the date you sent your appeal to court for them to provide evidence. But you are saying that they are wrong, so they have to come and provide the evidence that this is why we have refused the application. Once they do that, you have also time to file your evidence, and the total time you have is 42 days from the date you submitted your appeal. So if we have 42 and Home Office is taking 28, please do the math for me. 42 minus 28, what do we get?
42.
So 12 minus 8, 4, isn't it? Yeah, and we have 28 already, 10, and we have this. So 14, right?
14.
So put together so that viewers will know. 28 plus 14, what do we get?
28 plus 14 is 42.
42. That means if Home Office has 28 days, then you have 14 days after Home Office bringing their evidence to file your evidence. What if Home Office doesn't bring their evidence forever? Will you say they haven't brought it, so I will also send mine? How many days do you have? 42.
42 days.
So if they are not doing it, you do yours. And you have 42 days from the date you put in your appeal.
That's right.
Timeliness. And once you do yours, they tell the court that, look, they have not been compliant. They didn't even provide the evidence. And yet, they are yabby trying to say X, Y, Z. Yeah. And so, yeah, yabby is a new language. All right. Yeah. So
I keep telling you that Lawyer Asma brings it so down to our level so we can understand. And just to kind of retreat before he lands on that point, we are saying that if the Home Office refuses your visa and you have the right of appeal, you need to satisfy 3 things: prepare, get evidence, and act timeously. Because if you don't, then it means that, one, you probably may accept the decision of the Home Office, say, well, if you have refused me, that's it. But then if you're going to court, you don't have to go and waste the court's time. You don't have to your own time, and you have to bring relevant things that will go to support your evidence to say that the Home Office was wrong. You got all this from BWF solicitors and also from the program, the community, and the law. We're taking just this quick break to tell you about our social media handles. And when we come back, Lawyer Asma will land on his point, and then we will take your questions and your concerns. Remember, I've given you the scenario based on the nugget, talking about somebody who's born in the UK, not born in the UK, what kind of rights they have and all the rest of it. I'll bring that back and also look at the scenario and ask you the question again. Is the community and the law? We're back with you, and thank you for sticking around live on BWTV at BWF Solicitors Facebook and YouTube, and at BWTV UK Facebook and YouTube. Lawyer Charles Asma from BWF Solicitors is here with us and taking us through the ingredients we need for a successful visa refusal or appeal in court. Um, the lines are active, but we'll go back to Lawyer Asma. The lines are active 0208 493 7345. You can send a text or WhatsApp message, voice for the inviters 073 468. Or you can leave that in the comment section down below. Last one. Yes, we're back with you and we want to find out how all these things pans out: preparation, evidence, timing, and then what?
Yes. So this is all it. What did you say? How does it work?
We have that is a pan out.
Yes. I didn't want to use a pan that we use at the kitchen.
No. Obviously, we have a pet in the pan.
So it's today is a P thing, isn't it?
Yeah, it's a
the pan and the pet. Yeah. So I mean, you won't get it anywhere. We don't just bring you knowledge. We bring you something to laugh about so that you can ease stress and get ready, refresh for the next week. So, producer, please take us to the rule book. We touch on a couple of things just to offer context to the conversations so far. If you can give me bigger, sort of make it legible for me to zoom in or to zoom out. Sometimes I understand. Yeah, okay. So we have overriding objectives we've touched. So timeliness will go under that. Again, case management powers. Timeliness will go under that, and exceptions will also go under that. So anytime you are making a request to the court to consider you for something, you say, court, you have power under Rule 4 to do ABC for me. I come to you in peace and in humility. Offer me your ear, and the court will listen. Okay. Yeah, all right. So then we'll go to the next one is a procedure for applying and giving direction. That is for the court. So the court will always provide direction how things should go. Failure to comply with rules, go to 8. What will happen if you don't follow the rules? Please go, 6. That's 6. Click on 6 for us, please.
Failure to comply with rules, etc.
What will happen? Please, let me be brief on that.
Okay, so an irregularity resulting from a failure to comply with any requirement in these rules, a practice, direction, or a direction does not of itself render void the proceeding or any step taken in the proceedings. And 2 says if a party has failed to comply with a requirement in these rules, a practice, direction, or direction, the tribunal may take such action as it considers just, which may include waiving the requirement, requiring failure to be remedied, or exercising this power under paragraph 3.
Very good. So when it comes to the court power, the court can do so much to give you second chance or to punish you on the court. Timeliness is very important to the court. Now, there's a case law called the case of Ono. Ono is a Nigerian, and so when it comes to sanction by the court, the court will want to ask whether the failure is something serious. And in all circumstances, the failure can be waived. If the court considers under its powers that the failure, even though it is, can be waived because it's not so serious, the court will waive it. It doesn't make the decision by the court finally void. And that's why I say that the court sometimes can make exceptions. But your job is to make sure that you follow the rules and when necessary, ask court for such waiver. Producer, please go back and take us to the filing your evidence, please. So we go down to calculating time. Okay, I think we mentioned calculating. So 11 calculating time. So what are the things we've said are there. Calculating time, please.
So it says an act required or permitted to be done on or by a particular day by these rules. A practice direction or direction must unless otherwise directed, be done by midnight on that day. And subject to the tribunal directing that this paragraph does not apply, if the time specified by these rules, a practice direction or a direction for doing any act on a day other than a working day, the act is done in time if it is done on the next working day.
Yeah, so depending on the circumstance, whether it's a weekend or a working day, you have to make sure that if the court has given you time, that for example, we talked about 14 days. When does the 14th day end? 14th day will end midnight, before the midnight. But that midnight will be the 15th day. So 11:59 p.m. is the end of the 14 days. So that is what the court is saying. Otherwise, then it has to be where the court says that, for example, working days, that will be a working day. So then it doesn't matter whether you submitted on a weekday, a weekend or not. So all these things are important when you are calculating the time, whether 14 or 28 days, as we spoke about. The producer, please take us back to the rule. And let's touch up on rule 14. Rule 14.
Evidence and submission. This one also talks about, without restriction on the general powers in case management powers, the tribunal may give directions as to A, issues on which it requires evidence or submissions, B, the nature of the evidence or submissions it requires, C, whether the parties are permitted or required to provide expert evidence, D, any limit on the number of witnesses whose evidence a party may put forward, whether in relation to a particular issue or generally, and E, the manner in which any evidence or submissions are provided, which may include a direction for them to be given.
So under 14, it's about evidence and how
it's presented
and when to be presented and submit. So the court is clear in the rules. So far, all that we have said is from here. And so as part of the preparation, as part of the ingredients for a successful appeal, you cannot lose sight of the procedure rules. Let's call it the marking scheme by the court. What is the court's marking scheme? The court is not going to mark and say that we give you 100% or we give you 10%, but the court is going to mark to decide whether to accept your appeal or not, or to throw it or reject it, so to speak. So it's important that if you are doing it through your lawyer will understand the rules. But if you are doing it yourself, then you can't say, I don't understand the rules, that's why I'm doing this. You still must have a bit of appreciation of the rules. So it's important that we refer to this. Please take us to Rule 23 and the end of it. Rule 23 back. Take us back to the content. Rule 23. What does it say?
Now, 23 says this rule applies to an appeal against a refusal of entry clearance. 2 says when a respondent is provided with a copy of a notice of appeal from a refusal of entry clearance, that is F2, the respondent must provide the tribunal with A, the notice of the decision to which the notice of appeal relates, and any other document the respondent provided to the appellant, giving reasons for that decision. And it goes to be any any statement of evidence or application form completed by the appellant, any record of an interview with the appellant in relation to the decision being appealed, and any other unpublished document which is referred to in a document mentioned in subparagraph A or relied upon by the respondent. The notice of any other appealable decision made in relation to the appellant, any documents provided to the respondent in support of the original application. These are the responses and the expectations of that.
So who is this for? Who is this? Who is the court talking, or the law talking to? It appears that they are addressing the Home Office.
The Home Office, the respondent.
Yeah, the respondent. So the Home Office is supposed to provide all this evidence. So when you go to the rules, it will tell you that if the Home Office has provided all this evidence, don't repeat them.
Oh, okay.
Don't repeat them to make your work easier. So you narrow in on the evidence to the issue.
Okay.
So the Home Office must provide a refusal decision. Is there. So if they have given it and the court is looking at it, they don't also have to bring it. But the court is looking at it for both of you. Home Office must bring the evidence of the things they are relying on and the reasons why they refused you. So apart from the refusal decision, Home Office may make reference to certain things. The rules say they must provide everything.
Right.
And so once they have provided everything, you, the appellant, will also provide your evidence, but don't repeat the evidence from the Home Office. So if you have options, which evidence will you present to court? The ones that favor you more, which the Home Office has not provided.
Okay.
And they wouldn't have it because if they had it, they wouldn't have said no to you. And so you have it, and you have to bring it and highlight it. Okay. So court is trying to save time under the overriding objective, time saving. So where it is provided, you don't repeat that. It doesn't also mean that if you repeat it, they will punish you. They won't punish you. So sometimes you have it in your bundle, but your focus should be on what you need to support your point. So by and large, we have looked at preparations you need.
Okay.
We have looked at the evidence you need. And in all this, the timeliness of your evidence and preparation will make the argument for you.
Lawyer has ended on time, so I will also go on to timeliness. It's time for you to have your questions and concerns answered. So we'll be picking some from the comment section down below, some from the text messages you said. And if you would want to speak to lawyer yourself right here on the program, 0208 493 7345, 0208 493 7345, or you can send the text to 0739920846. I'll start off with the comments in the comment section down below. Let's pick up some of the questions that we have sent. You have sent in. Eunice is saying that currently in this country on a care visa with my wife and 4 children, we have been able to acquire a mortgage this year for our own house. What's our fate going forward? Lawyer.
Yes, it means you don't have to rent anymore. All right. That's the first point. Well done. Well done. Good point. I mean, you see, that is what the program is all about. You come into work, but at the same time, you use the resources that you accrue from working in a manner that will support you and your family. So it's good that you've acquired a home. The next thing to consider is you have to look at your next visa step. I don't know whether you've gotten your indefinite leave to remain yet, but it appears that they haven't gotten there yet. And so you have to work towards your indefinite leave to remain once you have done 5 years on that program. So make sure that you stick to the employer, make sure you meet the requirements so that you can apply. After that, you can, after 5 years, you get your indefinite. After 1 year on the indefinite, you can apply for naturalization for yourself and your children. And then you become a citizen of the United Kingdom and your fate has been made complete.
Well, thank you very much. If you have just joined us, it's time for us to pick up your questions and your concerns. It could be about the topic we discussed this afternoon, or any other thing that's bothering your mind when it comes to the law. Let's pick up the next one. And this one is from Frank Agor. If law changes, isn't it going to affect people married to British citizens under the 5-year rule for indefinite leave to remain? I don't know whether you're referring to the update we gave earlier on. Yeah. So I'll throw it back to you, lawyer.
Frank, I agree with you. I would have thought so. That what was going to be the fate of those who had the expectation that after 5 years on that category they can progress to indefinite. There is something called the starting of the law, or when there is new policy. Where does it start? Is it going to be applied retrospectively? Excuse me, or is going to be applied from the point the policy was introduced? It appears, and over the period, if you study the trend to date, every time there's a new policy, they make provision for those who are already in that category and exempt them and say that from today go. And if that trend must be followed, then I should be able to suggest that potentially the policy may make room for those who are already in. So if you're already in 5-year route as a spouse, with the expectation that after 5 years can apply for indefinite leave to remain, then the policy, keeping to consistency and precedence, will make provision for you. And so I want to believe that it will start from those who are going to be coming onto the program or making such applications once the rule is or the policy is introduced. But Frank, this is my view. Don't take my view as advice. We're all waiting to see what the government will say. But I'm praying that the government will follow its own precedents, as has always been the case.
Keep them coming through. Text number 0739920848. Studio lines active 0208-493-7345. Or from the comment section below, either on Facebook or YouTube at BWF Solicitors, BWTV UK. Emmanuel, can two people on a certificate of sponsorship, whether a dependent or main applicant, marry in the UK without going to Ghana? Can someone given 70 days to leave the UK marry someone on POS in the UK without going back to Ghana and by extension their home country? Lawyer.
We answered this question last time.
I think so. Yeah.
We said that's the one you said that it's 60 days, not 70 days.
Yeah.
But CO, you know COA, is it COS? Okay. COS. So okay, what it means is I come in as a dependent of my wife.
Yeah.
And somebody else comes in as a dependent of a husband. Me, a dependent. She, a dependent. The two of us fall in love. And we abandon our first love and take this new love. As a dependent, can I marry another dependent? The answer would be no. You can marry, but not with the view to be sponsored by that person.
Okay.
But that person doesn't have leave to be able to sponsor you under.
Yeah.
What about the person I have found, the lover I found, is a skilled worker, main applicant. Can a person sponsor me? Yes, on that basis. That's the difference. So dependent, no, repel. You repel. Dependent, main applicant, attract. So repel. So like pose, unlike pose. That is how it will work.
Okay. Yeah, I told you that he will take us to the classroom. Like pose, attract. Negative, repel. Anyway, yes, keep them coming through. Let's see what Jennifer has brought. How long does it take to receive my decision from the Home Office after making an application in the UK? So, in-country application, Home Office, how long does it take to get a decision from them?
Right. So, let's take Jennifer's point again. How long does it take to receive a decision from the Home Office after making an application in the UK? Well, it depends on what type of application. But at the same time, generally at the moment, Home Office is saying that it's taking longer than usual. Even skilled worker applications are taking longer than usual. The standard was 6, it went to 9, and they said 12, and now they are saying unlimited. So if your application is unduly delayed and your lawyer has tried everything, get your MP involved. I've spoken to most of my clients that get the MP involved. Let's my so bring the MP on board, and myself and the MP will push so that the power will be stronger, and together we can get them to make a quicker decision. And that's what most of my clients have started doing. So get your MP, tell your MP that your lawyer has tried everything, or if you did the application yourself, you've tried everything, it's been this number of months late or not delayed. The MP will follow up for you so that at least something can be prompted on.
All right. Thank you very much. We have Nana Bafo, who has just joined us. You're watching with us. Thank you so very much. Let's pick up another one that's been brought up. Kevin Asamoah says that, can your partner in Ghana rent one of your building property out and spend your money without your knowledge? This is a personal matter.
Okay.
Can your partner in Ghana?
Can your partner in Ghana rent one of your buildings and spend your money
Without your knowledge?
Okay, but if it is a partner, it says for better
or worse.
And this is one of the worst case scenarios. And you must accept it. But if you are still not sure why you should accept this, get the family and the church involved so that they can resolve the matter peacefully. This is a family matter. You don't have to take it to court. Resolve it peacefully. Explain, let her tell you what she did with the money and if you can reinvest. Okay. All right.
But then I think by extension, I can ask this question. Can I see my partner?
See you?
Yes.
That's a good point. You see, when you, because this is going to be a dispute resolution matter, civil case. Civil means it's not a criminal matter. What did the person do? The person sold my property without my permission.
Yeah.
And this is, if I'm the one defending this other partner, the question will be this. You were somewhere in the diaspora. This wife or husband is home. Potentially driving children. You bring money, but not enough. If there's property, can we sell the property for the benefit of the children and myself? Or we should die so that you bring the money to bury us?
Well, I'll leave it in your bosom. Well, keep it coming. I know. Don't take me there. It's a whole topic for a whole
topic. But that's a very interesting one. Nobody has asked this question. Can I see my partner? But why will you see your partner? Is love gone?
Well,
that's not to
other part. I asked this question maybe with the knowledge of what we have done once on this program, where we talked about people buying property together and expressing kind of interests, the kind of interest people have in properties, and how you get these registered, whose name should be on there, if there's the need for us to go our separate ways, what are our interests and what are the kind of how we even split those properties and the rest of it. That's what I was asking. Can I sue?
Yeah, but for example, let's assume that you are taking action on the basis of theft, that a person has stolen something. If it is a family, we are saying that theft is defined as appropriation of property belonging to another person with the intention to permanently deprive that other person of their right in that property. This other person is your spouse. This property is for the family. So the question is this property belonging to somebody else or is belonging to us? If the property belongs to us, then it doesn't fit the definition of theft. That's point one. If it is a case of passing off, passing off is where you say that the thing is for me and the person has taken the interest in that for themselves without making me aware or without my permission. If your wife wears your clothes, or your husband wears your clothes, especially trousers, anybody can wear trousers, If my wife wears my trousers, or I wear my wife's trousers because we are the same size, have I offended? Have I passed off? If it is a property, it's for both of us, a piece of land, and I built on it for us. Have I taken something that doesn't belong to me? You see? And therefore, we have to open the conversation up to decide which one is it. There's also what we call constructive trust, where as part of my association with this person, especially familial associations, because I'm part of the person, we are one. We are living. We are making. We are building a family together. We are sweating and working together, building for both of us. If I don't pay anything, because you paid everything, does that make it yours alone? I might not have contributed financially, but I have contributed sweat and energy.
No, that's what I said. It's a whole topic for another day. Mr. Producer, I think we have to arrange for this.
Yeah. So Calvin's point, question about can I sue my spouse? You may not succeed in that suit, and the best option is to seek alternative dispute resolution as opposed to seeking litigation to resolve the matter.
0208-493-7345. Leave them in the comment section down below, either on Facebook or YouTube at BWF Solicitors at BWTV UK. I received notification from UKVI with successful visa, but almost 10 working days, no update from VFS still. I created my account and got my e-visa completed. What should I do next, lawyer?
Okay, it says no update. What sort of update? Is it the decision letter or something? But almost 10 working days, no update from VFS. Yes.
So I think probably he's expecting the passport and other things to come back.
Right. So the tranquil. Tranquil, yes, it's a very tranquil day. Today is very, very calm. My brother or my sister, please, we're not quite clear what the issue is. If a lawyer did it for you, let the lawyer follow up on whether it is the decision letter that is left or it's your passport. Usually the passport will come later. But I should say that 10 days is not a big deal. If it is in country, that's fine. You can continue because your e-visa will be activated. But if it is out of country, because you said VFS, that is out of country. In this case, your passport may still be pending. So please, it's also possible that they might have emailed you to go and collect the passport. So check your spam, ask the lawyer or whoever's email address you used. Tell the person to follow up to see whether they have prompted. Otherwise, just go there to ask them that I've received my blah, blah, blah. I haven't gotten my passport. Is there anything for me? If no, you go back home. If yes, you take your thing. So, okay, I'm saying all this because the question is not quite clear.
Okay.
All right.
All right. Thank you very much for that. But if you can provide us with further something that would be very useful. After property marriage in Ghana, can one include the children during the application on the spousal route? Dante Michaels is asking. They've done the proxy marriage in Ghana, and I think they're going on with the application, and he's asking, can one include their children during the application on the spousal route?
Well, when someone says, can I include my children, what they think is always different from what they expect to hear.
Okay.
So it's a double meaning statement. Sometimes when people add their children to the application, that is when the application form will ask, do you have dependents who are not applying with you? And they will give their details. Okay. To them, I added my family members. You haven't added your family members. You've only provided the details as part of the application, but you haven't added them to the application.
Okay.
Adding them to the application is where they are also applicants. And so you may be 3, and so you have 3 in one application. But with entry clearance, it's usually you do for each applicant. Okay. So if it is if you have done the application or you are submitting your spousal application and your children are not applying with you to the UK at the same time, then include their details on the application form. It doesn't mean that your children can automatically come to the UK whenever they feel like coming. You always have to apply. But because you've already indicated that you have children, In future, when you say you have children and that you want them to join you and their stepfather or stepmother, it's easier. But if you don't include their details in the application, and later you say that I have children, when you are applying, they would have asked you, do you have dependent children? You say no today, how will you be able to say yes tomorrow? And that is where it becomes complicated. You have to go for DNA, you have to do this and say, I didn't know why it was not added and all that. So please, if you are still not sure what to do, please contact us. We'll be happy to assist you so that you can get it right.
Happy to assist so you can get it right. What we have to do, okay, Tranquil has come up with something more. So, Lawyer, let's quickly do that. Then we'll go to our quiz and come back to round up. Tranquil says to collect my passport with vintage. I did it myself. No lawyer involved, but I learned a lot from you. What, Tranquil? Well done.
This is what the program is all about, to empower people to be able to do things that they couldn't do before. And so well done for demonstrating the tenet of this program. Yes, you've got your pass. It said to collect my passport. Okay, so to collect your passport, that's what I said. Um, the Vignette, that's what he meant or she meant by vintage.
Oh,
the
okay.
Vignette. So
Yeah.
the visa stamp in the passport. So at the moment, she's received the visa decision email.
Okay.
And she's done the e-visa profile. So the persons have done my e-visa and all that. Just that they don't have the passport to even travel, even though they have the visa ready to travel. So my friend email the
VFS.
the VFS to ask that when will my passport be ready? But usually they will let you know that the passport is ready. But if you still have time and you want to follow through on trial and error, go there every day. Go with the paper they gave you when you went for your biometric. Just go and say, I've got the decision. Is the passport there? If no, go back home. That is if you have time to be able to do that. Otherwise, wait or email them.
Well, as I said, time and tide, they say waits for no man, and we can never be exceptions to this. We still have two other things to consider. Now, the first one is the quiz I gave you based on the nugget I provided earlier on. And this was in our social media realm all throughout the week. Kofi Antoban was born in New York in 2017. When he was 2 months old, his parents came to the UK as visitors. In 2025, when Kofi turned 8, his parents applied for indefinite leave to remain on his behalf, relying on the new law under the private life category. They were told by No Kofi Advice Center that once Kofi has settled, they can apply for their own settlement. Then my question is, does Kofi qualify for indefinite leave to remain as he's been in the UK for more than 7 years? I give you three options. I ask you to choose one of them. Don't choose more than one, just one. Tell me whether you think that Kofi qualifies for indefinite leave to remain in the UK. Yes, because he's lived in the UK for 7 years or more and is under 18 years old. No, because he was not born in the UK, although he's been here for 7 years. No, because his parents do not have indefinite leave to remain. Citizen Kwejo comes up first. I think he sent it quite earlier on. Is one or A, yes, because he's lived in the UK for 7 years or more and is under 18 years. The next one from Ben Donkor says it's number 2. No, because he was not born in the UK, although he has been here for 7 years. Michael Frimpong thinks it's number 1. Yes, because he's lived in the UK for 7 years or more and is under 18 years. Nana Mensah also thinks it's number 1 as well, because Antobam has lived in the UK for 7 years. But Enes Obeng thinks differently. He says that's number 2. No, Kofi cannot have indefinite leave to remain because he was not born in the UK. Kweku Wafo agrees with number 2. Thank you, Kweku. Kweku Kwating thinks number 3. No, because his parents do not have indefinite leave to remain yet. Salome thinks that it's number 1 because Kofi has lived in the UK for 7 years or more and is under 18 years. Joyce Manso thinks number 3. Thank you, Joyce, for that. We take one more and we quickly go over to Lawyer Asma to see which one of you was correct. Frank Bosu thinks no, because he was not born in the UK, although he's been here for 7 years. Lawyer, 1, 2, or 3?
Right. So 1, 2, or 3 is in the nugget. So let's look at the nugget and pick the answer in there. It's hidden. What does the nugget say? So let's go through the criteria for this person. 1,
Yes. So it says the child is under 18.
and that child is under 18.
Yes. 2, the child was born in the UK,
That child was born in
New York.
So 2 is missing. Go to 3.
Okay, back to the 3, the child has lived continuously in the UK for at least 7 years.
And that child has lived for 7 years.
Yes. And would not be reasonable to expect the child to leave the UK.
That's discretionary. But if you say to qualify under this criteria, you
need to show that.
He didn't say you need to show one of the following. He said you need to show that A, B, C, D, E.
Okay.
So all of them.
All of them.
4 is discretionary.
4 is discretionary.
So we don't even have about 4. But so the first 3 are important. Now let's go back to the New York child. Does this child meet all the 3?
He was not born in the UK.
And so not 2.
So the answer is 2. This one is addition by substitution. Well, children born in the UK to parents who do not have indefinite leave to remain qualify for that if the children are under 18 years, they are left in the UK. It would be reasonable for them to leave the UK. So as Kofi, as I was saying, was born outside the UK, he would not qualify for indefinite leave to remain after 7 years of residence. Remember, the requirements are born in the UK, continuous residence, the age, and reasonableness to leave based on Appendix Private Life PL 3.1 of the immigration rules. So those of you who said 1 and 3, please, not to put it to you. It didn't work. Tilly, you said 3. Don't change it. I know definitely she was going to change it. But that's that for the quiz. Very exciting one. And we'll throw one in the mix again on Monday. So watch out for that with a nugget and the quiz. But today, what we discussed was the ingredients for a successful appeal when you have been refused a visa here in the UK. Lawyer Asma will summarize.
So, ladies, gentlemen, viewers, listeners, thank you for keeping faith. Today, we looked at appeal, and whether this appeal will be successful or not depends on you. What do we mean by depends on you? It all depends on how you prepare the appeal soup. What ingredient do you have to put together to make sure that it's very palatable? You need to prepare, understand the refusal reasons, understand whether it is something you have to fight for, and understand that there are things you need to have right. The next one is that you have to make sure that you have enough evidence relevant to the issue. And so once you've prepared and understood the reasons for refusal, you target the evidence to address the claim or the refusal reason. And your aim is to rebut, or the aim is to counter what they have said in the refusal. So you go with the relevant evidence that will go to give you more points and not to take points away from you. And in all this, you have to act promptly. And so we said you need to prepare, you need to gather and provide relevant evidence, and you need to act on time. PET, PET. And on time means that you send your application on time, you send your evidence on time, and everything must be within the court rule book or the procedure rules, so that the court will be happy to accept your appeal, and the court will be happy to entertain your argument. And the Home Office will not be able to challenge your argument and the evidence, because you've prepared enough and you've gathered relevant evidence, and you are hopeful and sure that you're able to succeed. This is what we brought you today. Thank you.
And this is where we're drawing the curtains down, because time and tide, as I said, waits for no man. It's been an exciting evidence that we have provided. We have prepared, we've provided the evidence, and we've acted timelessly. So definitely we hope that the court will grant our appeal. It's been granted, because same time next week we'll have another opportunity to come back your way with another edition of the Community and the Law. But first of all, join me to one which Pamela, happy birthday. Congratulate Annie for being the employee of the month of September. And to you out there for staying around and listening to what we heard. And most of all, let's say thank you to Lawyer Charles Asma for his time, the share of knowledge, and of course, being our friend. That's why we're so grateful. God bless you. And hopefully, if I can pull you out again, I'll do that same time next week. On behalf of Padma Dodu, aesthetics man, and Sheila Ankra, admin, and my indefatigable producer, Professor Ade, my name is Ureku Frimpong. We're all together wishing you a good evening.